Hello there, and welcome to yet another episode of Know Your Laws, where we talk on matters to do with law, justice, and legal to educate you, help you, and learn new laws. And on our last episode, we talked about matters to do with the succession law, explaining what is succession, who is entitled into succession, and that is what we talked about in our last episode, where we explained the application of the succession law here in Kenya. And we're going to continue with that discussion on our second episode of that particular matter to do with succession law with my guest, who is an advocate of the High Court of Kenya, Kevin Doho. Welcome into the program.
Asante sana.
Last week we talked about matters to do with the succession law, its application here in Kenya, who is to inherit and who is entitled to succeed a benefactor who has passed away. And now on this particular episode, we are going to major on that particular matter as well, but now on the new amendments of this particular act that governs succession law. But I want to begin at this point. Of course, succession is a matter that surrounds a marriage setup, of course, being contentious in a case where there is polygamy. But again, there is this aspect of cohabitation, where two people have been living together for quite a long time together, garnered wealth, properties, but now one of the partners, I can say, passes on, and now it's time for succession. At this point, who is to claim responsibility or who is to claim succession?
The law, where it's written right now on marriage, is that you have to have a marriage certificate. Without that marriage certificate, whether it is customary, Muslim registration, Hindu registration, Christian, or just under the Marriage Act generally, the one we call the AG's type of marriage, unless you're able to show a certificate of one of those types of marriages allowed in Kenya, you'll have a huge difficulty in trying to claim the properties of the person who is deceased, because you have not yet proven that you are a spouse. And one of the ways of proving you're a spouse is by producing that marriage certificate. However, there are certain aspects of the law that allow somebody to be presumed a wife for purposes of succession or a husband. And these are the elements of presumption of marriage. It's called the Yahweh versus public trustee case, where the law lords or the courts have established various elements of proving presumption. So you might have a difficult problem filing for the succession cause, because first thing that will happen is you'll need a letter from the chief, and the letter of the chief will tell the court who the dependents of that person are. If the chief obviously agrees that these people used to live as husband and wife and do not have a certificate, he'll just write a letter and say that this person died and left behind this one. It was a purported common law wife. Common law in the sense that he's not a wife, she's not a wife, or he's not a husband under the Law Succession Act, but under various customs or various presumptions of that relationship. So you'll be running around in circles in trying to prove that you are a wife, because as I've seen recently, some wife or widow somewhere was disinherited by a court, even after she came out and said and proved that she had 5 kids with the deceased husband. So the court had tried to authoritatively state the intention of Parliament. Parliament, as it enacted the Marriage Act, wanted to cut out that aspects of that you have been seeing in Kenyan funerals of prominent persons, that once a person dies, certain spouses up and say they were a spouse. So to avoid that type of behavior and that type of scandal, Parliament just said everybody to get a certificate. So the court, in that sense, tried to uphold the intentions of Parliament, obviously to the great prejudice of somebody who would have relied on the presumption of marriage aspect of inheriting from somebody whom they cannot produce a marriage certificate.
And now, because cohabitation legally recognized marriage in Kenya, and in that scenario, someone feels like they have stayed for long with that particular person, and they're also entitled to succession. But again, here comes the immediate family members of the deceased who say that we are entitled to inherit what our family member had, and because the cohabitation that they had with the supposedly wife isn't recognized by the Kenyan law. At that point, does the law now lean on the side of the family, or it tries to hack in the most fair way?
Obviously, right now the law has been amended to support family. If you didn't go pay him a dowry, you are a stranger to that wife, or you were just picked up by the man. Over the several years you've been married, you've never been introduced to the family. Everybody will find it very suspicious that now you are coming to claim that you are a spouse to that person. Obviously, the way the law is written right now is you need a marriage certificate. Once you're able to produce that and you are married under the Kenyan law, then it answers the claim by the family that you're a stranger or a volunteer into that type of succession that you're trying to do. But if you cannot produce a marriage certificate, it's going to be a very, very contentious succession proceeding, because on the one hand you'll have the family coming to court claiming that you are not a wife or a husband, and you'll be trying to prove presumption. Then if you're trying to prove presumption, one of the elements is that you are to be husband and wife over many years, that you had cohabited, they had been treated as husband and wife. So one element of disproving presumption is that you are not known. There was no indication that you are husband. Who knew that you are husband and wife? If the family of the immediate don't know you, you might find yourself failing in trying to prove that you are a husband or a wife of a deceased spouse.
And on that regard, do you feel there is a loophole, or rather loopholes, in the law whereby in certain scenarios it does not act in striking a balance in between parties?
Yes, the law of succession is the law of somebody who's not there to tell his story anymore. Either we are relying on a will, or we are relying on the reputation that this person was married, or we are relying on this person saying that they were children and this one is saying they are not children. So the law of succession is one of those areas where there is supposed to be very sober judgments of character, of proof, of burdens that have to be is it on a balance of that will be dependent on a case-by-case basis. One of the loops is oral wills. Will somebody and say, this man, when he was dying, 2 months before he died, he said that only the boys should inherit, or so and so should inherit, and things like that. You know, this one now is 2 witnesses that need to come and prove that it was an oral will. Sometimes it's even in mother tongue, and basically somebody might come with that loophole and claim that they were the only ones entitled to inherit, because either the mother, when she was dying, she said this should inherit. On other aspects, you might find yourself facing claims by creditors, what we'd call strange bedfellows, in the sense of terms and claims. The deceased sold me this land. He was not able to afford school fees for the child. I am the one who provided him with money. That's why this child proof of a debt on the estate, unless you can be able to produce an agreement for sale, or you're able to produce witnesses to say that this person sold me the land. So you might find yourself in the deepness of succession law in very murky waters where you need proof, and sometimes the proof might be cooked. There might be various aspects. An amending act in Parliament that has tried to redefine or clearly define what intermeddling is. Intermeddling is when somebody interferes with the deceased's property. They have even made a provision that says if you throw out the wife or the child from the estate or from the house or from the property of the deceased, that's intermeddling. And there are various definitions of intermeddling to include selling of the deceased's property or invading and living on a deceased person's land or property or taking over their cars, things like that. Mm-hmm. The law presumes all assets of a deceased person are supposed to be saved and they're supposed to be maintained, pending the court determining who gets what. So between the person dying and the property moving to the people who have survived the deceased, that property is nearly government property. Mm-hmm. It's nearly government property because it's not government property in the sense of it belonging to government, but government protects the assets of a deceased person because they can be wasted or somebody can start doing funny things with the property of a deceased. Anyway, the owner is no longer here to defend himself. So one of the laws that has really protected the estates of deceased person is now the Law Succession Act, a point where it provides for intermeddling and says intermeddling is a crime punishable by this amount of time in jail. The other part of the law that protects the estates of deceased persons is the Penal Code, where it outlaws the destruction, the theft, or the illegal production or creation of fictitious wills and testaments. So if you find yourself caught up in that type of criminal offense, you might find yourself spending nearly 14 years in jail. That is now how the government has gone, or many governments in the world have gone around trying to protect deceased persons. So those loopholes, they have tried to seal them, but you see, these are criminal offenses over the estate of a deceased person. So you might find there being a bit of difficulty trying to enforce that type of civil or criminal offense or fraud. So there are various aspects that we are trying to close, but in the nature of human affairs, criminal offenses are still happening. We are still having intermeddling. We are still having disenfranchisement of widows and orphans in this country, and the various mechanisms of doing that usually depend on somebody being able to hire a lawyer and go to court and prove his dependency, or reporting the same to the police and they're able to take charge together with the provincial or the county administration in the protection of those assets. And you might find yourself also having to do letters to various banks, various land registries, where you can, if you don't have anything else, you just go and register the death certificate over the land. So at least the land registrar knows this money, this cannot just be moving, and yet the person is deceased, things like that. So there are many loopholes, but they are all dependent on somebody doing some mischief somewhere.
You know, the Kenyan law now trying to close those loopholes, and until recently is when the First Amendment and the Succession Law was made. And the biggest contentious matter in that particular amendment was determining who is the actual dependent in different definitions of children, stepchildren, maybe the wife, maybe like a former wife or parents of the deceased. Of course, that is a matter that has been for long contentious, and now in amending this particular succession law to make it to close those loopholes, in that when a succession matter arises, it's so easy to determine who should inherit and lock out who is not supposed to inherit. Is that the first step for closing those loopholes?
Yes, people have suffered, and Parliament has responded by clear and trying to make there to be an equivalence or an equality between the genders. Previously, it used to only, a dependent could be only a woman or a child of the man. It had left out men in the sense of dependency. Now, the dependent is a spouse as defined under the Marriage Act. So you come and you prove that you are a spouse by saying what? By producing a marriage certificate. Other loopholes of the children used to have difficulty before the Affiliation Act, I think 1985. You had disabilities on bastards or children born out of wedlock or things like that. Now, when Parliament passed the Affiliation Act, it was not really an act under the law of succession. It was now a separate act that now removed that liability of born out of wedlock. So this is something that was in the works for the longest of times. So once you remove that disability, now we come under the current constitution. They said a child has the right to support from both parents. So whether you are born in a wedlock or out of wedlock, under the Constitution 2010, now you could claim equal treatment with the children of that marriage. So if you're a child born out of wedlock and during the lifetime of the deceased you are discriminated against, things were not going well, but one side of the family where we had somebody, maybe the man has married another wife and has sent the children to live with the mother, or the wife or the mother moves in with a man and has other children and moves her children out of that home and takes the former children to live with her mother, as these children in this side are benefiting. The Constitution now and the law that has been amended says you can't do that anymore. Once one of those parents dies, all the children of that person will inherit, must inherit, because unless there is adoption, there is only one father, there is only one mother. You can't have two mothers or two fathers. So the person is to inherit is a person who gave birth to him, the biological father, biological mother. Does not matter how that man or woman or that father or mother lived their lives. Once you are deceased and you had chucked or you had thrown away children, and you had the children of one woman, or you had favored only the children you had with one man, and you forgot the aged children that were married, that you had with other men before, the law does not now allow that. It says all children are equal before the law. Yeah.
And now, of course, that is more clearer in determining who is to inherit and who is not to inherit. Of course, proving for the legally married spouses, succession, of course, in times where there is a will written. You talked about fraud and inclusion of irregularities in trying to prove that indeed you are entitled for succession. At one point where a will is left by the deceased and produced by one party, and the other contentious party moves to court and says that will was not written by the deceased. It's not that is not a will that the court should use to determine succession. Now at this point, does the court now have to go back to the drawing board and determine each aspect of the spouses, or they act on the will?
Yeah, that is called proceedings called setting aside of a will. When you're setting aside a will, you can allege fraud, you can allege coercion, you can allege undue influence. Those are various heads of determining issues to do with wills. And because of the way dangerously favoritism, there's sometimes a lot of favoritism in wills, it might be that not very many people trust wills to this day. Very few Africans have been writing wills because of this. So you might find somebody just says, no, I can't write a will. Either I can't court death. You know, the various superstitions that are emanating in our African society. Or somebody might say somewhere and sit down and create a will from nowhere. He just comes and says, this is what my father wrote, this is what my mother wrote, and I am the one to get on loan. So you might have to prove fraud, and to prove fraud is not easy. To prove you have to prove it near at a standard of beyond reasonable doubt. Not beyond reasonable doubt, but nearly that high. Because he who alleges in law is the one who's to prove. Now, these are the aspects of setting aside a will on undue influence. You have to prove that during the lifetime of this person, when he was writing the will, there was undue influence. For example, there's a famous matter where a former minister, at the time he was dying, he was being moved from place to place, cat and mouse game between the families. He had 3 wives. So you might find he's one day in Aga Khan, the other time he's in London for treatment, the other time he passes on in South Africa. So all through, you might find it's only one daughter who has been with him. And during that time, there's a will that is produced from nowhere. So the court might sit down and say, no, there is no way he would have written this will, and yet he did not have freedom of moving around. He was already sick. He was moving from hospital to hospital to hospital. The circumstances where this new will was created, it's very suspect. So it will set aside because of undue influence. Undue coercion sometimes. For example, you might find somebody is told, here, Shosho, sign this, we will not give you food. Or if you want to take a bath, you sign here, So you might find if those circumstances are proved, that will not be held. It will not be upheld. It will be set aside.
Okay. Yeah. And now on that particular scenario, of course, as we are to the conclusion of this particular bit of succession matters, there is a property that the deceased has left behind that is supposed to be inherited by the kins. But again, the deceased before is probably untimely death. Of course, maybe a property such as a land, a building, they had used them as security to get is that loan the deceased want to repossess the property in compensation of the loan that they gave him. And now the family also says this property is subject to inheritance. So at that point, what really transpires in determining what goes ahead in regards to that particular property?
This one is now what we call private law. 2 aspects of private law. The law of succession, which is private law, and also the law of land law, Land Registration Act, which is the law of commerce. Now, when you're looking at those 2, the bank will have to claim as a creditor in the estate of that deceased person, because once a person is deceased, you can't do anything. Who are you going to serve the statutory notices on for you to exercise a statutory power of sale? You can't. You have to serve on the administrator. If no one wants to become an administrator, or they are delaying, dilly-dallying administration process, then the creditor has the aspect of giving a cease or desist letter to the people who are supposed to be administrators and tell them, if you don't come to court and take, we as creditors will take administration papers. And what happens is that once you are appointed as administrator as a bank to execute your charge, your loan, or whatever, you have to account. So they usually say debt before gifts. So first aspect, when you are administering the estate of a deceased person, you first pay out the debts. Then the bequests or the gifts come after you have paid the debts.
Okay.
So first, the estate of a deceased person is X. You deduct the creditors. Whatever is remaining will be distributed either according to the will of the deceased, if there was a will, or according to the laws of intestacy, where everybody gets equal shares. But if there is nothing left, there is nothing to be administered, and that estate is defunct. And if there is aspect of debt not paid, that the debt was so large that it went more than assets, then the bank will be left with problems with a bankrupt estate, and then you'll have to follow the laws of bankruptcy. Was there assets that were hidden? Are there things that you can see were being done in mischief so that you can avoid your debt, then you have to deal with that according to how your advocate will advise you.
And someone would argue that if the deceased had taken a loan and secured that loan with the properties subject to inheritance, would say that once the person who took that loan is deceased, the loan and the recovery of the loan should be considered null and void. Is that argument valid?
No, the loan will have to be paid back by the sale of the assets of the estate. Once the assets have paid back the loan, whatever assets are remaining are now what will be inherited. Debt before gifts. That's the law. You can't be giving people property that belongs to other people, or the deceased had already sold the land to somebody else and the money had been used to pay hospital bills. Now, and says, no, this land was not, it is now our inheritance. No. If the deceased had already sold it, the asset will be transferred to the person who sold it. So you can't really come and claim against a creditor who has proven his debt.
And now, as we conclude, of course, succession is a matter that is so much contentious, or of course affecting each and every person in their different environments. Your final remarks in regards to someone who feels that they have been neglected in a succession. What would be your advice to anyone seeking succession?
You just get your proof that you are dependent and go see your advocate. Then they'll be able to advise you.
And that is where we wind up this particular discussion. Of course, succession is a matter that is so huge, and of course we'll be continuing the discussion with the different amendments, aspects of its application here in Kenya. But for this particular episode, that is where we wind up our discussion. Thank you so much for making time for this particular discussion. That has been my guest, who is an advocate of the High Court of Kenya, Kevin Ndoo, talking on matters to do with succession. And that is where we wind up this particular episode. But remember, you can always follow us on our social media pages, where you get to learn more about these particular episodes. Leave your question, we'll be answering. And if you want to reach the advocate directly, you can do so through our social media pages, so that you can be, what do you do in terms when you need to be educated on matters with succession. That has been our episode. My name is Chris Sambo. Remember to catch our next episode. See you. Goodbye.